Good afternoon, everyone, and thank you for joining us. On behalf of SBA Lawyers, we're pleased to welcome you to our webinar on the recent Supreme Court decision in Eamon versus Trillium Mutual Insurance Company. Some of you may know that this is a significant decision, in particular when addressing the scope of guaranteed rebuilding cost coverage and the treatment of regulatory compliance expenses and property damage claims. I'd first like to introduce you to my co-host, Stas Bodroff, who is a partner in our Toronto office, who has a broad practice with a focus on property and CGL claims. My name is Rory Love, and I also practice in our Toronto office. My practice primarily focuses on property damage, products liability, and CGL related disputes. Just a little bit about SBA, which is a full service insurance defence firm, and we have offices in Toronto, Kitchener, and London. Just a little bit of housekeeping to let you guys know that the webinar is being recorded and will be uploaded at some point next week, and it'll be shared across our various platforms if you wish to provide it to any of your colleagues who couldn't make it today. If you do have any questions or comments, please reach out to Stas or I afterwards and be happy to answer them. So our plan for today is to go through the facts of the case, the key coverage issues before the court, and any practical implications that these types of issues would have on claims handling. I'll begin with a brief overview of the facts that have given rise to this dispute and explain why a covered flood loss ultimately evolved into a significant coverage battle before Canada's highest court. With regards to the facts of the loss, in late April 2019, there was a significant flooding along the Ottawa River, which led to the complete destruction of the insured's residence. The property was insured under a homeowner's policy issued by Trillium Mutual Insurance, and there wasn't a dispute that the flood triggered the coverage, but there was a disagreement on the cost of rebuilding the insured's home. Because the property was in a flood sensitive area, it fell under the authority of the Mississippi Valley Conservation Authority, which regulates development and reconstruction near the river. Before the rebuilding could begin, the Emmons were required to comply with the Conservation Authority's regulatory framework. Those requirements included additional construction measures and new standards that were not in place at the time the home was originally built. The new regulatory obligations had a direct financial impact. The approvals required for rebuilding significantly increased the costs and changed what would have been a fairly straightforward replacement into a much more complex one. The increased expenses were not discretionary and were mandatory in order to rebuild the home as it was on this regulated floodplain. Now, Trillium acknowledged that the flood damage constituted a covered loss under the policy, and they didn't dispute that the home had been rendered a total loss. However, there was a disagreement on the scope of the insurer's responsibility for that rebuild. The central question was whether the policy required Trillium to cover these increased costs with the regulatory requirements that were necessary that come into force after the original build. The insured's perspective, these costs were part of the lawful rebuilding of the home. The insurers, from their perspective, identified various exclusions and endorsements that would have limited the coverage for these costs, driven by the changes in the regulation. As a result, the dispute moved away from what was just a straightforward property damage claim towards an interpretation of the policy as a whole. On that note, I'm going to pass you over to Stas, who's going to discuss the coverage issues in more detail.
Thank you, Rory. So as Rory mentioned, this obviously did reach the highest court in Canada, Supreme Court of Canada, who did a good job for the bulk of the decision going over the basic principles of interpretation of insurance contracts. I'm going to take a moment to go through those principles and the methodology of interpreting insurance contracts, and then Rory is going to delve into how it was applied to this particular loss. So the court reiterated the generally advisable order of interpretation that was set out in a previous decision of Ledcor and Northbridge. And ultimately, they reiterated the fact that first, the insured has the onus of establishing that a damage or a loss falls within the grant of coverage provided by a base policy. Second, the onus shifts to the insurer to establish that one of the exclusions in the policy applies to exclude that specific loss from coverage. And finally, the third step is the onus shifts back to the insured to establish that an exception in the policy applies. The court noted that exceptions do not create coverage, but they bring an otherwise excluded claim back within the original coverage endorsement, coverage grant. The court also considered how endorsements should be treated in the context of this interpretation. And the court reiterated that endorsements are not self-contained or standalone contracts or policies that are disconnected from the general insurance policy. The endorsement changes or amends the underlying base policy and is built on the foundation of that base grant of coverage. When considering insurance contracts, the court noted that effect should be given to the clear language that's included in the policy that's unambiguous when reading the contract as a whole. The wording must be given the ordinary and grammatical meaning, which means that it has to be understood by an average person applying for insurance. The court contrasted this with an insurer's generally better and more specialized knowledge of insurance and noted that the jurisprudence doesn't favor insurers who rely on specialized knowledge. So insurers can't rely on their more thorough understanding of the policy to get a more favorable interpretation of the provisions. The court noted that it expects insurers to ensure that the policy terms are clear, express, and easily intelligible. From there, from the unambiguous portion of the contract, we see that in some provisions will obviously give rise to ambiguity. And ambiguity arises when there's multiple reasonable but differing interpretations of a policy. However, the key here is that the differing interpretation has to be reasonable. The mere articulation of a differing interpretation doesn't establish the reasonableness of that interpretation and doesn't by itself create ambiguity. So terms must be looked at in light of the contract as a whole, and there must be an alternative reasonable interpretation of the clause. So the court identified that there's typically two cases when ambiguity will arise. One is when a provision itself is unclear in isolation. So the provision alone is unclear. And when read in the context of the whole contract, it continues to be unclear, or there's more than one reasonable meaning that can derive from that provision. The second situation is when a provision appears to be clear in isolation, but when read in the context of the whole contract, there may be more than one reasonable interpretation of that provision. So when an ambiguity is identified, the court must then look to try and resolve that ambiguity. And when doing so, there's three general factors that are considered. The first is the reasonable expectations of the parties. So the contract must be interpreted to be consistent with those reasonable expectations. Second, the interpretation should not give rise to a result that's unrealistic or would not contemplate the commercial atmosphere during which that policy was formed. And third, the interpretation has to be consistent with interpretation of other similar insurance policies. If after looking at trying to resolve the ambiguity still remains, the court has to resort to the principle of contra proventum, which in essence means that the ambiguity has to be resolved in favor of the insured. And when doing so, you have to consider the broad coverage and interpret it in a broad fashion. When looking at exclusions, you have to interpret them narrowly. And when looking back at exceptions to those exclusions, they have to be interpreted broadly. And again, this is done to favor the insured because it recognizes the unequal bargaining power between an insurer who has specialized knowledge in the product that they're providing and who has power over drafting the policy itself, and the insured who's trying to get that product. The court here also talked about nullification, or the nullification of coverage doctrine. And they observed that Ontario courts have long refused to apply the exclusion clauses in contracts where the effect of that exclusion is to virtually nullify the coverage of that policy. So the doctrine prevents insurance contracts from being constructed and construed in a way so as to defeat the coverage that the policy at its very core provides. Critically, the court noted that this nullification of coverage doctrine applies even if the language in the policy is unambiguous. So if it is clear what the policy coverage is, if it is clear what the exception is meant to exclude, if the effect is that that coverage is nullified, then this principle will kick into effect. The idea here is to recognize the fundamental fairness and ensure that insurers don't pocket premiums without assuming some kind of risk. And again, the court was very clear and repeated several times that this doctrine applies regardless of whether the language of the contract is unambiguous. So as it relates to this specific case, Rory's going to get into the decision of the Supreme Court in just a few moments. But before he does, I want to bring you up to speed on how it got to the Supreme Court. First, the matter came before the Superior Court in Ontario. And at that point, the court decided that Trillium had to pay replacement costs that included the cost of complying with the Conservation Authority requirements. The court noted that the GRC endorsement was clear and unequivocal, but that the compliance cost exclusion did not apply. So the EMONs were successful at the Superior Court level. When it got to the Court of Appeal in Ontario, the appeal from Trillium was allowed, and it was noted that the compliance cost exclusion applied to the GRC endorsement, with the exception of $10,000 that was included in an exception. From there, the matter was appealed, and I'm going to pass it over to Rory to talk about what the Supreme Court of Canada decided.
Thank you. As discussed earlier, the core issue before the Supreme Court was not whether the loss was covered, but how three separate policy provisions intertwined to define the scope of the coverage that was going to be allowed to the Emmons. Firstly, the insureds had purchased the guaranteed rebuilding cost, the GRC endorsement. This optional endorsement allowed them to rebuild their home using comparable materials and modern construction techniques. This was even where the cost of the reconstruction exceeded the policy limits. This endorsement also expressly confirmed that all remaining policy provisions continue to apply. The second area that they looked at was the compliance cost exclusion, which removed coverage for additional expenses arising from legal or regulatory requirements affecting the repair or reconstruction of the property. And thirdly, there was a separate building bylaw and code compliance endorsement. This provided only a modest capped extension of coverage for certain regulatory driven construction expenses. Now, the dispute turned on whether the GRC endorsement displaced the compliance cost exclusion or whether the exclusion continued to operate despite the enhanced rebuilding coverage. As Stas mentioned, the analysis was completed using the framework from the Ledcor decision. And importantly, the court confirmed that this sequencing remains intact even where endorsements are involved. And endorsements are not standalone contracts. They modify the base policy and must be read in sync. Applying that approach, the majority concluded that the GRC endorsement altered only the basis of indemnity, as in the amount payable for an otherwise covered loss. It did not expand the underlying scope of coverage or remove existing exclusions. The endorsement enhanced the quantum of recovery by limiting the monetary cap on the rebuilding costs, but it did not change the types of losses the insurer had agreed to cover initially. As a result, the compliance cost exclusion remained fully operative. The endorsement contained no wording that suggested that the exclusions were displaced. It actually stated that all other policy terms remained unchanged. And the court emphasised that the clear exclusions continue to define the limits of coverage unless the endorsement contains explicit language otherwise. Now, the insurers argued that the endorsement's own title, which was guaranteed rebuilding cost coverage, and its reference to rebuilding with current building techniques created ambiguity, suggesting broader protection. This was rejected by the majority. It held that the headings and marketing language cannot override clear operative provisions. The word guaranteed could not reasonably be interpreted as limiting all policy limitations, and the reference to modern construction methods was interpreted as addressing how rebuilding would occur, not whether the regulatory compliance costs were covered. Regarding the exclusions, the court reaffirmed the fundamental principle of insurance interpretation. The exclusions remain enforceable unless clearly displaced. The compliance cost exclusion was found to be clear and unambiguous. Interpreted according to its ordinary meaning and from the perspective of a reasonable policyholder, it plainly targeted costs driven by legal or regulatory requirements. The Emmons also relied on the doctrine of nullification, which Stas spoke about earlier on, arguing that applying the exclusion would deprive them of the benefit of the GRC endorsement. The court disagreed with this. While the doctrine may apply where an exclusion renders purchase coverage effectively worthless, it did not apply simply because an exclusion limited recovery. In this case, the GRC endorsement still provided significant value by removing the policy's monetary ceiling on rebuilding costs. Because the endorsement continued to deliver a meaningful benefit, the exclusion did not nullify the coverage. Ultimately, the Supreme Court's analysis reinforces a disciplined approach to policy interpretation. Endorsements must be read with the broader policy structure. Clear exclusions remain effective unless expressly displaced, and enhanced rebuilding coverage does not automatically convert regulatory or compliance-driven costs into insured losses. Now, of note, this was not a majority decision, and there's some interesting takeaways from the dissents, as well as the key takeaways from the case as a whole. And I'm going to pass you back over to Stats for that.
Thank you, Rory. So that was the majority decision from the Supreme Court. This was a 7-2 decision, so the 7 justices decided as Rory just set out for you. But there was 2 justices that dissented, and generally speaking, dissents are, one would argue, less valuable, obviously, than the majority, as it's not binding on any courts below. But what we're likely going to see going forward is insureds trying to differentiate their cases from the majority decision. And we anticipate that they will likely be relying on the dissents to try and push forward their positions going forward. So the 2 justices that dissented was Justice Cote and Karakatsanis. Justice Cote wrote I guess, the bulk of the decision, which Justice Karakatsanis agreed to. So they agreed on the way that the matter would resolve from their perspective, but they came to that conclusion with slightly different approaches. I'm going to set out each of their dissents briefly, just to give you an idea of the arguments that we're likely going to be seeing moving forward. So Justice Cote set out the same interpretive framework from LEDCOR, but differentiated the result, noting that if there's an exclusion in the base policy that is meant to limit the coverage that's granted by an endorsement, that limitation should clearly be articulated in the endorsement itself. And the purpose here is to try and promote clarity for interpretation of the contract. Justice Cote concluded that there was ambiguity in the policy itself, which is why it led to a different conclusion. And Justice Cote noted that there were three main ambiguities. One coming from the title of the endorsement, so guaranteed rebuilding cost coverage. An average person would understand the term guaranteed as a promise that the rebuilding would be paid for and compensated during a loss. The second ambiguity was the phrasing that Rory mentioned a few moments ago, using current building techniques. This could be interpreted to include rebuilding in compliance with current legal requirements, not just the methodology of rebuilding. And finally, probably the biggest ambiguity that Justice Cote identified comes from the structure of the policy itself. The GRC endorsement itself did not have any exclusions. And when looking at the structure of the policy itself, you will see that Section 1 of the policy listed the exclusions in the base policy, which is where the compliance cost exclusion was found. Section 4 then listed the endorsements, and it listed the exclusions for those endorsements. And many of the exclusions that were found in Section 1 were listed in Section 4. However, the cost compliance exclusion that was listed in Section 1 was not included in Section 4, the endorsement list. So that created ambiguity. And having found that there's an ambiguity in the wording and the interpretation of the policy, Justice Cote went on to try and reconcile the ambiguity by implementing those three steps that I mentioned a few moments ago. So when considering the reasonable expectations, it was noted that the insured bought a top of the line coverage, and they expected that for the paid increased premium, they would receive the rebuilding costs to be covered in the event of a loss. When considering the context of the policy itself and the commercial context, the insurer knew that the house was built in 1968. They knew the rebuilding would require compliance with modern standards, and they valued the property based on the modern rebuilding costs. So based on Justice Cote's interpretation, it would be illogical to calculate premiums based on compliant rebuilding today, but deny the compliance cost after the loss. So Justice Cote concluded that the compliance cost exclusion did not apply to limit the GRC, but it limited the compliance costs to those that were required by law that were in effect at the time of the last renewal. So when the policy was bound, it was Justice Cote found that at that point, the insurer was aware of the commercial realities. They were in a position to assess the value of repairing the property if it was subject to damage, and those costs should be covered, but not if a law changed after the policy was bound. Justice Karakatsanis agreed with this interpretation, again, noting the same interpretation steps, but Justice Karakatsanis focused on a slightly different portion of the policy, finding that the phrase increased costs that were noted in the exclusion was an inherently comparative provision. And as a result of that, it was ambiguous. Trillium took the position that the increased costs was relative to the time of construction, so from 1968, versus the Emons, who noted that the increased cost was relative to the time when the policy was issued. So because of this ambiguity in that specific clause, again, you would have to consider and try to reconcile the ambiguity. And when trying to reconcile the ambiguity, Justice Karakatsanis did the same thing and reviewed the factors when trying to reconcile an ambiguity in the policy. So considering the reasonable expectations of the parties, Justice Karakatsanis noted that the homeowner would not expect an exclusion to be buried among unpredictable risks. So, as I mentioned a few moments ago, the exclusion that was being relied on was included in Section 1 of the policy, which listed all of the other exclusions, such as war, nuclear events, and other unpredictable risks, which silently eliminated coverage from compliance with the law that already existed. So the position of Justice Karakatsanis here was that if an insurer was going to be relying on a provision, on an exclusion, then that exclusion should be more clearly articulated and not be buried among unpredictable risks. When considering the commercial reality, again, Justice Karakatsanis noted that insurers set premiums and they understand and have a better um, knowledge of the industry, including the existing regulatory requirements at the time that a policy is bound. Therefore, the existing compliance costs at the time that the policy was bound were predictable and accessible at the time of underwriting. Given that there's this ambiguity and considering these factors, Justice Karakatsanis opined that coverage must be interpreted broadly and the exclusions should be interpreted narrowly, which again supports the insured's position. Justice Karakatsanis noted that the compliance cost exclusion does apply to the GRC, but it excludes the costs resulting from laws that were enacted after the policy was issued and bound. So, what are the key takeaways from this decision? So, first, the Supreme Court reiterates the importance of the standard contractual interpretation that was set out in Ledcor and Northbridge. In that regard, nothing has changed, it's just reinforced. The endorsements, but a small kind of change to that is that or reiteration more, is that endorsements aren't standalone insurance contracts, but they alter the base coverage that is provided in the base policy. From here, when considering exclusions in the base policy, those can, and when the wording is similar to that of, in this case, the exclusions from the base policy would apply to endorsements. But I want to just reiterate that the dissents here do give a good point of trying to ensure that the exclusions are clear and articulate, and it would probably be best practice to reiterate any exclusions that are in the base policy to include them in the endorsement so that it is crystal clear. Again, I note that this court and consistently courts have been interpreting policies to favor insurers when there's an inconsistency and when there's some ambiguity. And the point here is, and the expectation is that insurers strive to be as clear as possible in both the structure of the policy as well as the wording itself. And finally, although this court didn't dig too deeply into how the nullification principle applies, because it didn't really apply in this case, the court did provide a fairly in-depth review of this doctrine. And I think that the point here was in order to try and bring attention to insurers to review their exclusions and really confirm that those exclusions don't nullify the purpose of the coverage itself. Even when the policy is not ambiguous, the wording is clear, and everything generally is accepted, and there's no other ways to interpret the coverage as well as the exclusion. If an exclusion nullifies coverage, that provision will not be enforced. And that is very critical for insurers that are going to be relying on exclusions, which we do regularly, but to make sure that it's targeted and it doesn't nullify the base coverage that is being put forward and the purpose of the policy itself. Now, I see that we're coming up to the 30-minute mark, and I do want to thank you all for attending. Rory and I are available to answer any questions. Just feel free to shoot myself or Rory an email, and we'd be more than happy to assist you. And I do thank you so much for attending today, and I hope you have a great weekend going forward.